Thank you, Your Honor, and may it please the court. My name is Paige Ellis, and I represent the respondent, the state of Indiana, in the case before us, Indiana v. Walker. This case concerns the constitutionality of Fourth Amendment search and seizure with third-party consent. We are here on the basis of decision to whether or not the collected evidence of marijuana should be admissible depending on whether third-party consent was valid for an unwarranted search. Your Honors, the decision of the trial court should be affirmed today due to two explicit reasons. The numerous precedents justifying Fred Cooper's valid authority to consent on the basis of common authority, as well as the reasonable belief that the police had that Fred had authority to and could give consent. This reasoning should uphold the constitutionality of the search, the admissibility of found evidence, and the validity of third-party consent to affirm the trial decision.
So, counsel, I'm a little worried about the circumstances here because these young men are college age, and so if the police show up at the door and say, will you sign this consent to search, to someone who's been living there for a day, who's probably 19 years old, I mean, is it really appropriate for that to happen? Doesn't it put him in a very difficult position because he probably doesn't even know that he can say no and doesn't have to sign a consent form?
When the police were asking Fred whether he had common authority over the bathroom, they did this, and with his response, Garrett assumes the risk of a further decrease in privacy by permitting him to use his bathroom. And that's what the police recognized when Fred gave him this answer, because that automatically gave Fred the common authority to be able to give consent, because Garrett assumed the risk of the further decrease in privacy by permitting him to use his traditionally explicit, private rooms of the apartment.
Okay, so even if I agree with your argument that Garrett sort of assumes the risk that his privacy has been diminished by giving Fred this permission, what I'm concerned about is the behavior of the police. Like, shouldn't we expect more from the police in these situations? In previous precedents, the police were interacting with adults, right? And this is the police interacting with college students. Shouldn't they be more cautious? Shouldn't they explain to Fred, only if you're really confident that you have authority over, this bathroom, should you sign this consent form?
Although they probably could have asked more questions regarding the true common authority that Fred was given, Garrett gave Fred permission to use his bathroom. And as I said before, that assumes the risk of a decrease in privacy. And overall, this shows that both of them had a lower expectation of privacy, given that they are roommates in the situation. So although they are young and they may not recognize that what the commitment of being a roommate really entails, that still proves that they have a lower expectation of privacy for one another. Living in an apartment, despite their age, Garrett assumed the risk of a further decrease in privacy. And the police did ask questions regarding whether Fred truly agreed that he had permission of the bathroom, in which he did agree.
So I'm assuming Garrett wouldn't understand the implications of his decision to let Fred use his bathroom, right? So if I say to someone, oh, you can use that, in my mind, you can borrow my phone, say, because your phone is dead and you need to make a call. I'm not thinking that you might then give my phone to the police if they ask to search my phone, right? So that's my concern, is that I'm sure Fred never anticipated that events were going to unfold in the way that they did. So shouldn't we then, just under the sake of caution, say, no, we should find the search unconstitutional, because I can't imagine that Garrett ever thought allowing a friend to use a bathroom would result in that friend allowing the police to search that bathroom.
Garrett most likely did not assume that Fred would be in the medicine cabinet. However, the fact that he allowed him to use the bathtub, which is part of his bathroom exclusively designated for him, and the only way to get to that bathroom is to walk through his bedroom. Overall, this whole situation is proving, just again, his lower expectation of privacy. He may not have thought that he would be going through the medicine cabinet, but however, just going into these exclusively designated rooms that are for Garrett, that overall just proves that he had that lower expectation of privacy and expected, maybe not the medicine cabinet, but did expect an intrusion of his personal belongings.
Good job. Thank you, counsel. Again, hard question. She didn't get flustered. She kind of stood her ground, and she conceded as well. So you don't always have to stick to something. So she said, "Oh yeah, you're right. I'm sure he didn't assume that Fred was going to then give